Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat, feel free to have a drink, and join me. Let's get started.
So if you've been following the Stephen Avery case, there was this documentary, Making of a Murderer. I want to say that it debuted in 2014. There was a season 2 of it that came out like in 2018 or so, something like that. They have been fighting this case in the Wisconsin State of Appeals for a number of years now. They had an appeal that was pending, and they just got a decision that I'm going to share with you guys briefly. And there's not a whole lot to get into, but just know that his appeal has been denied. And this is what they say. Let me get into this. All right. Get out of that. All right. So this is some of the background. This is the third time that Avery is before the Court of Appeal. We have previously summarized the facts of the case in State v. Avery. If you recall, if you're not familiar, Stephen Avery was accused and convicted of murdering Teresa Halbach. I want to say back in like 2009 or something like that. There was a whole documentary about it. It's called Making of a Murderer. It's on Netflix to this day. And if you're not caught up on that, I would urge you to go watch it because it's one hell of a watch. It's been refuted by competing documentaries. Those are also worth a watch. That they try to paint Stephen Avery in a more negative light than the Making of a Murderer series does. But this has been on appeal, and this is where we're at right now. So this is the third time on appeal. So for context, on October 31st, 2005, Avery arranged for Teresa Halbach, a 25-year-old professional photographer, to photograph a vehicle at Avery's Auto Salvage. At the time, Avery's Auto Salvage was located on a 40-acre piece of property owned by Avery's parents, Ellen and Dolores. Avery, along with his brother Charles, lived on the property and worked at the salvage yard business. Another brother, Earl, worked at the salvage yard but did not live on the property. There was people. So as relevant, Bobby Dassey, who's also sitting in the jail cell right now, was then 19 years old, said to have an IQ of like 82 or something like that, reported that on October 31st, 2005, he was looking out a window from his family's trailer and saw Halbach arrive at approximately 2:30 p.m., take photographs of a vehicle, and walk toward Avery's trailer. Bobby then stepped away from the window. He never saw Halbach again. On November 3rd, Halbach's mother reported her missing. On November 5th, volunteer searchers found Halbach's RAV4 in the Avery salvage yard. The vehicle was covered with branches, plywood, and the hood of another vehicle. And they continue on with the facts of the case. So, in 2009, Avery moved for a new trial. This was after he was convicted, in part based on the circuit court's erroneous exclusion of Avery's third-party perpetrator evidence during trial. Avery wanted to implicate several alternative perpetrators in Halbach's murder, including, as relevant for the present appeal, Bobby. The circuit court denied the motion, citing third-party liability evidence proffered by Avery identified a large group of individuals who he claimed were near the Avery property on the date of Halbach's murder, but who he acknowledged had no motive to harm her. This evidence failed to satisfy the legitimate tendency test under State v. Denny. In other words, it wasn't pled with enough particularity that it would be likely to succeed on its motion, or that there was a legitimate claim to possible third-party culpability status, and therefore motion denied. So in 2017, Avery files another motion with Wisconsin Statute 97406, raising new claims. The circuit court denied the motion, and Avery filed motions to vacate and for reconsideration, as well as 2 supplemental post-conviction motions. And one of his supplemental post-conviction motions, Avery included an argument that the state withheld evidence, and this evidence would have established a Denny third-party perpetrator defense that Bobby had motive to kill Halbach. The court rejected Avery's arguments without a hearing, and Avery appealed. On appeal, Avery argues in part the state improperly withheld evidence that Avery could have used at trial to establish Bobby had a motive to kill Halbach. Avery pointed to the final investigative report of Detective McKay-Velli, saved on a CD, which Avery claimed he received in 2018. Velli created this report through forensic examination of the hard drive of a computer from the Dassey family household. Velli's report identified items such as pornography, internet search terms, chat messages from the Dassey family computer. Avery argued that the violent pornography contained on the Velli CD could have been used as Denny evidence because it revealed Bobby had a propensity for sexual violence. When they're talking about Denny evidence, they're talking about evidence that leads to motive, and therefore a motive to kill Halbach. We disagreed. We determined the state did not improperly withhold evidence because it was disputed that Avery's trial counsel had been given a copy of the Dassey family computer hard drive, and the Velli CD did not contain any additional information other than what was provided to counsel. In other words, if you thought that was a thing, you should have raised it at the time of trial, and you didn't, and so therefore you lose. Good day, sir. Hey, full points if you know where that's from, Dominic.
I know.
God damn it. You got to be kidding me. You lose. Good day, sir. You can't tell me you don't know where that's from. Oh, my God. You're so deprived. We also determined Avery failed to establish trial counsel was ineffective for failing to analyze. Yeah, that's where they go. So there's 2 points of analysis here. Number 1, you already had the CD way back when. And so if you had it way back when, you should have raised that issue when you had it way back then. And why are you wasting time on appeal now? 2, I guess you could try to argue, well, my attorney was stupid. And now they're speaking to that other point, ineffective assistance of counsel. We also determined Avery failed to establish trial counsel was ineffective for failing to analyze the Dassey family computer hard drive. We first noted that Avery's assertions that only Bobby could have downloaded the images from a communal computer used by several people were factually unsupported. We then explained that even if the Velli CD could be used to establish the motive prong of the Denny test, Avery failed to meet the direct connection requirement in its original Denny motion and has not presented additional evidence on this point. Therefore, Avery could not demonstrate a reasonable probability of a different outcome at trial. In other words, no different evidence. You don't get 2 cracks at the apple. Case closed. In 2022, Avery filed the Wisconsin Statute 97406 motion underlying the present appeal. He first argued testimony from his newly discovered witness, Thomas Sawinski, provides the missing direct connection between Bobby and Miss Halbach's murder, making him a Denny suspect. In support, Avery attached Sawinski's affidavit to his motion. Sawinski averred that before sunrise on Saturday, November 5th, 2005, he was delivering papers to Avery's Auto Salvage. While there, Sawinski saw Bobby and an unidentified older male in his 50s or 60s with a long gray beard pushing a dark blue RAV4 down Avery Road on the right side towards the junkyard. Bobby did not look happy to see Sawinski and attempted to step in front of Sawinski's vehicle to prevent him from leaving. Sawinski swerved around Bobby and called out, "Paperboy, gotta go." Sawinski believed that Bobby and the older individual were doing something creepy. That's evidence. Sawinski learned Halbach's RAV4 was found in the salvage yard later that day. Sawinski averred he contacted police, and an officer told him, "We already know who did it," as well as told him they contacted him but never did it. How about that? Let me get off of that. In his motion, this new evidence allows for a reconsideration of the real motive of his crime as being a sexual homicide, which was the culmination of an obsession by Bobby with viewing thousands of images of violent, deviant pornography On October 31st, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Halbach was brutally assaulted and murdered by 2 rifle shots to her skull. Her body was mutilated, as were many of the female subjects in the Dassey computer images. Funny, when I saw the documentary, I really thought that at the very least, they were going to get a hearing out of this. Because even if you believe that that is, weak evidence for motive, I mean, it's enough to at least raise the issue at trial. So I was actually a little bit surprised when they decided to deny this appeal. So there was a previous motion. He goes on. So this is the discussion. The issue in the case is whether Avery's Wisconsin Statute 97406 motion was sufficient on its face to entitle him to an evidentiary hearing. As a threshold matter, we observe that on appeal, Avery makes no argument regarding the sufficiency of his pleaded Brady or interest of justice claims. That was a mistake. As to Avery's newly discovered evidence claims and whether its motion was sufficient to entitle him to an evidentiary hearing, sufficiency of a post-conviction motion is a question of law, which we review de novo. If the motion raises sufficient facts that, if true, shows the defendant is entitled to relief, the circuit court must hold an evidentiary hearing. If the motion is conclusory, or if the record conclusively demonstrates that the movement is not entitled to relief, the circuit court may deny the motion without a hearing. In his motion, Avery alleged that he had newly discovered evidence from a new witness that between Bobby and the Halbach murder, and planting evidence to frame Mr. Avery. When seeking a new trial based on the allegation of newly discovered evidence, a defendant must establish by clear and convincing evidence, which is a pretty high standard, that the evidence was discovered after conviction. And that's kind of the problem that he's had the entire time. All of these things seem to have been known, or what should have reasonably been known, at the time of his initial trial. And now you try to raise these things on appeal after the fact. You can't really do that on appeal court, in appellate court. I suspect that's going to be part of the reason for his denial. Clear and convincing evidence that the evidence was discovered after conviction. Defendant was not negligent in seeking the evidence. The evidence is material to an issue in the case, and the evidence is not merely cumulative. In other words, we've already gone over this over and over and over again and keep on trying to pile on. We've decided the issue long ago. The circuit court determined that the Sawinski evidence satisfied the first 2 prongs. Wait, where did I leave off? Once the court looks to whether a reasonable probability exists that a different result would be reached in new trial. So the circuit court determined that the Sawinski evidence satisfies the first 2 prongs of the newly discovered evidence test. Evidence was discovered after Avery's conviction, and Avery was not negligent in seeking the evidence. So he got that part of it. I don't know. To me, if he gets that part of it, then that should at least warrant an evidentiary hearing. I got to hear this, their reasoning here. The circuit court stopped its newly discovered evidence analysis after it determined that Avery failed to demonstrate that the evidence was material to his third-party perpetrator defense. Third-party perpetrator evidence is only material if it would be admissible under this case. On appeal, Avery argues the circuit court erred by only analyzing the materiality of his newly discovered evidence within the confines of a third-party perpetrator defense. He argues, in determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, the court completely ignored its inherent materiality to the other material issues in Mr. Avery's case. To the extent Avery's post-conviction motion could be interpreted that the Sawinski evidence was independently material of any third-party perpetrator defense, we conclude his motion is insufficiently pled. What the hell? Avery only analyzed the Sawinski evidence within the context of a third-party perpetrator defense. As one example, the 4th prong of the newly discovered evidence test requires a defendant to establish the newly discovered evidence is not cumulative. In regard to that prong, Avery offered a single sentence. The Swinsky evidence provides for the first time the missing direct connection to Bobby as a third-party suspect for Miss Halbach's murder and is therefore not cumulative. Well, that's because by definition, if it's being offered for the first time, it's never been offered before. Therefore, it's by definition not cumulative. Avery did not offer any analysis that explained why his newly discovered evidence was not cumulative outside of his third-party perpetrator defense. As another example, in Avery's analysis of whether a reasonable probability exists that a different result would be reached at trial, Avery argues, if Bobby is established as a viable third-party Denny suspect, the forensic evidence in this case is completely undermined. The newly discovered evidence that Bobby was in possession of Miss Halbach's vehicle means that he had opportunity to access to plant evidence in the vehicle and from the vehicle because Bobby had been directly linked to the murder of Miss Halbach. There is a reasonable inference that he planted the bones in Mr. Avery's burn pits. This new evidence creates a reasonable probability that had the jury heard the new evidence, it would have had a reasonable doubt as to the defendant's guilt. Before I read even any further, that still doesn't solve the logical conundrum of, even if he would have had opportunity to do that, would he have had the materials to plant Avery's blood inside the vehicles such that it would make him or implicate him or serve to frame him in the commission of the crimes? Again, Avery did not offer any analysis that explained why his newly discovered created evidence created a reasonable possibility of a different outcome. On retrial, that was independent of his assertions that Bobby murdered Halbach and framed him for it. The circuit court properly recognized Avery's newly discovered evidence was not independent from Avery's attempt to meet Denny and addressed whether the evidence was material within the confines of his third-party perpetrator argument. In other words, he tried this argument before and he's trying it again. And that kind of serves as a death knell for his appeal. Avery next argues the circuit court erred by denying his post-conviction motion because he asserts his newly discovered evidence satisfied Denny's legitimate tendency requirement established Bobby murdered Halbach and framed him for it. Avery contends the circuit court erroneously imposed a substantial certainty requirement and misapplied Denny in its evaluation of whether Avery's proffered evidence satisfied the Denny elements of motive, opportunity, and direct connection. How long is this thing? All right. So we're getting into a whole long explanation of what he wrote, and they're not going to publish this opinion. All right, they're getting into the reasons of his denial. That's where I really wanted to start. Let me get into that. Okay. Where was I at, Dominic? Page, I think I found it. So we'll start with motive. Motive refers to, we know what a motive is. In this post-conviction motion, Avery asserted Bobby had motive to kill Halbach because Bobby searched for violent pornographic images on the family computer, which established Bobby had an obsession with violence and was more likely to commit murder. In support of his theory, Avery first alleged in his motion that there were 1,625 violent pornographic images recovered on the Veli CD. He stated that pornographic images depicted violent images. These statements are not supported by the record citations offered by Avery in his post-conviction motion. His computer expert's affidavit, which he cites in support of his first proposition, does not establish there were 1,625 violent pornographic images. The report simply states that there was additional images categorized as recovered pornography. Nothing in this affidavit established that each recovered pornographic image was violent. As for Avery's next assertion that the recovered images depicted violent images of the torture and mutilation of young females, Avery cites pages from his computer expert's affidavit in support of that proposition. However, again, the page citations offered by Avery do not establish all of those things. That being said, we recognize the record does at least suggest there were some pornographic as well as gory images found on the Dassey family computer. We will therefore assume, for purposes of Avery's post-conviction motion, that there was some quantity of what could be classified as violent pornographic images on the communal computer. But even with that assumption, the fundamental problem with Avery's motion is that he fails to tie these images to Bobby. In his post-conviction motion, Avery attempted to tie these images to Bobby by arguing that because Bobby routinely worked night shifts. Okay, so I'm starting to see some of the issues wrong with his appeal. We're going to have to revisit this on a different show. This appeal just came out. The decision on this appeal just came out on the 15th. I am kind of shocked that this did not render a new evidentiary hearing for Mr. Avery. We're going to dive into that next week when I further examine what's going on legally with why the appellate court reasoned that this doesn't warrant an evidentiary hearing. And then we will pick it up from there. But folks, I've been talking for how long now? Like an hour, 45 minutes? Yeah, I think it's time. I think it's time for us to do some FLAD. So we're going to do some Family Law After Dark. We're going to wrap up today's show for today. Dominic is going to cut up today's show and start releasing several different videos from today's show. But for the rest of you guys, I will see you guys over on Family Law After Dark in about 5 minutes. I love you guys. Have a good weekend. Bye-bye.